amounting to fraudulently. There are another 3 rules which the court has been very clear. It is unless you bring your case within those 4 rules, you cannot be able to it cannot be able to review your judgment. But again, it has to do that within 14 days.
Is there a difference on the way the court would review, if at all, its judgments as opposed to its rulings?
Oh yes. The court has clearly stated that it has no mandate to review rulings unless the matter is fully finalized. So the court will be ready to review a full judgment instead of a ruling, because rulings are basically meant to guide the people on how to ventilate their matters in court.
Yet there must be finality in the judgment, correct?
Yes, because there is judgment in final. And again, because in judgment, there is nowhere where one is going to appeal. Okay? So when it comes to judgment, the court gives people leeway to review their judgments.
You answered the question before I asked it.
Sorry, please.
So let me now ask the question. Yet there must be finality in judgments. And these are judgments of the apex court. You couldn't go anywhere else after that. So what does the court say? And I'll direct you to Outa. Outa is a famous case in this place on the topic you and I are discussing now. What does the court say about review of judgments? Are you familiar with Outa?
Outa? I'm familiar that what the court has clearly said, it cannot be able to review judgments unless somebody brings his judgment within those 4 grounds.
All right. Let's make progress. Learned Counsel, what is the difference between the court departing from its judgments and reviewing its judgments?
Now, when a court, my lady, when a court reviews its judgment, it simply means there were errors on the face of the judgment. So the court is trying to correct certain mistakes on that judgment. Now, when the court departs from its judgment, that simply means the court, maybe because of certain developments, the court is now giving a new form of judgment, even though the facts are the same. But it is now, because the court is not founded on precedent, it is now giving another form of judgment, which is totally distinct from what it had given.
What is the principle that guides the departure from judgments by the Supreme Court? It's in Article 163.
The only reason is that why the court should depart from its judgment is maybe the matter in question is of national importance.
It is that all courts except that court are bound by the decisions of the Supreme Court.
Yes.
And so that is the one court, the only court that has power from the Constitution to depart. Let's go to another issue. Let's relax this a little. Learned Counsel, what would you say is your favorite judgment from your dream court? What would you say is your least favorite judgment from your dream court? In either case, please give us reasons.
I've read several judgments from that court. There is the judgment of Waswa.
No, our question here is specific. It is your favorite, your least favorite, the reasons for...
Yes, I'm going to give that to you, my lady. The judgment which I find quite interesting and quite fulfilling is the judgment for one Waswa, where the court came up with the concept of victim, the rights of the victim. I want to say, my lady, I have worked for the last 10 years in the international criminal tribunals, and mostly in other jurisdictions other than the adversarial system. The victim is given center stage in all cases. The victim. In fact, the problem with our adversarial system, we neglect the victim and try to think that when we have imprisoned someone, we have brought injustice. Take, for instance, a young girl impregnated in the rural area. You charge the victim, you are charged the accused.
May I redirect us to Waswa? Please tell us why Waswa is your favorite case.
Because Waswa brought the victim to the center stage in proceedings.
Yes.
The victim was recognized through Waswa. I think now most victims in our courts can be able to defend themselves. They can be able to indeed sit in court and say justice has been done. Mm-hmm. Now, the least case that I find, I don't find it, but I find it interesting, is the usual Murwatetu. Murwatetu came up with far-reaching consequences in the sense that, in fact, most of those people who are convicted of murder, okay, have been resentenced. Now, if you look at that judgment, there is no mention, even the old judgment of a victim. The case looked at the rights of the accused person. But never at all, the court never at all said, how about this person whom Murwatetu killed? This person had children. This person had a family. This person, the graphic way in which the murder was done. The court never looked at it. The court just went and said, this guy has rights. So his rights have to be vindicated. So that's because, sorry, my lady.
What was the issue in Murwatetu? Wasn't the issue a directed issue? When are the circumstances that the court should determine a matter not directly placed before it for determination? Was the court in Murwatetu not asked? You spoke earlier, which I thought was the role of the CJ, about the way to file pleadings, how to keenly draw the issues for determination, all right? Now, so what were the issues for determination in Murwatetu, and would the court legally and rightly, and to what extent, go outside the framed issues for determination to determine the secondary issue of victim in the case of Murwatetu?
Thank you, my lady. The Supreme Court is the biggest court in the land. Under the Constitution, Article 159 empowers the court to do justice, such that the court cannot shy down from doing justice. The court needs to look at all areas of justice. So the court cannot say, the issue before me is just making a death sentence mandatory. The court should have also asked, how did Murwatetu get this death sentence? What did he do? The court should have gone back, and I think that's what I'm saying. If the actual file in the High Court was in the Supreme Court, the court should have looked at the graphic way in which Murwatetu murdered his victim. Then the court could have said, yes, we agree, the murder should not be mandatory. In fact, we agree the judges have a right to take mitigation, to look at mitigation, but we still affirm your sentence, or we can reduce your sentence. But instead of giving all these accused persons, more than 5,000 of them, leeway to come out of justice when indeed they have killed people.
Now, it's interesting how you view Murwatetu. Can Learned Counsel lead us to the point where the Supreme Court took away the power of courts to impose the death penalty?
No. What happens, I think, my lady, and this is what I was saying, in jurisdiction like the International Criminal Court.
Let us remain with Murwatetu.
Yes, I'm trying to compare. For instance, when I was doing my case at the ICC, the judges would write to you and say, Nyabei, before we give our judgment, can you address us on this issue? So they will say, yes, you have given us your issues, you have given us what you think is good in justice, but address us on the victims. What is the right of the victims? So the court never went out to ask on that.
Yet, the question is whether the Supreme Court, in the specific case of Murwatetu,
yes,
took away the power of courts that try murder to impose the death penalty. That still remains the question. No,
my question is, the court did a wonderful job in the sense that it declared the death penalty not to be conclusive, not to be the only penalty. Okay? My problem in Murwatetu is not that. It's not on looking at mitigation. My problem in Murwatetu is the conclusion. Okay? So I'm saying, having looked at all this, the court could have said now, in conclusion, we find there is an issue of victims. How did Murwatetu come to court? So I'm not castigating the court. In fact, no, I really feel the court did a wonderful job.
Even if you did, it's your right to do that. In fact,
yes,
at we time, we would have gone to the next issue. But you see, you are right to the extent that you are telling us what you like least and your reasons for it. That's
yes,
exactly what you're doing.
Yes.
I was just attempting to get you which you want to evade, Kabisa, and I'll leave you at it.
Thank you.
Whether we took away the power of courts below us to impose the death penalty, but let it remain unanswered. My final question will be two-legged, and the first is what you understand by the inherent power of the court.
The inherent power?
Of the court.
Yes.
What judgments you know the court has dealt with there. And secondly, which judgments of the court you think are contradictory, if you agree with those who have been saying that the court has been giving contradictory judgments. And with that, my brother, I wish you well.
Thank you, my Lady Chief Justice. I want to say this: the inherent power of the court simply means the substantive power which the court must have for it to deliver justice. The court must have discretion. That's one of the inherent powers. If a judge has no discretion to make a ruling, then he does not have that inherent. So inherent power simply means that power which a court has, which makes it to make a ruling. And I want also to submit, my lady, that the present constitution has enhanced that power. The present constitution. In fact, one of my perceptions is that courts used to be when the court says, when section 150, article 159(1) says that the citizen has surrendered his power to the court. What that section means is that the court or the judge or the magistrate now takes center stage in all proceedings. He has even more power. He does not need to sit and be passive in court. Okay, and that's why I was going to request, maybe at certain time, you as commissioners, you may need to visit some of these jurisdictions in other than the adversarial. Then we can be able to learn how courts take center stage in proceedings. And I think that's where, because at the end of the day, if you have to do justice, you must take center stage in proceedings. One example which I want to give is when I was appointed an amicus curiae stroke consultant in the ICC, the court wants to give justice. So what the court will do, we have got several consultants. If the court finds a gap instead of delivering judgment and saying the prosecution never brought this evidence, the court will send Nyabei to Rwanda, to Cameroon, and do investigation, and bring that investigation to the court so that the court can make an informed decision. In fact, a court could hardly give a decision by saying there is lack of evidence, because it is supposed to do justice. It is supposed to do justice for all. So the court will go out of its way and say, either it will write to me and say, please, we have these gaps. Can you fill them? Can you give us, can you explain? If you don't explain, it is able to send, it is amicus curiae to those jurisdictions so that they can bring evidence and be able to give justice. So, my lady, what I'm trying to say, that inherent power, without it, the court cannot do justice.
There was something about contradictory judgment.
Thank you, Chair. You want to answer the second part of my question? Contradictory.
Oh, for cases, I think I don't have cases right in my mind, but there are a number which have been decided by the court. I've read them.
Okay.
The question is, if it assists in any way, if it doesn't, you just forget it. There's been criticism that the court issues contradictory judgments. Are you aware of any?
I want to say this. The court, the court has not really issued contradictory judgments, to my knowledge. In fact, it's a court which is trying to open up space which was not there. For instance, if you look at the arbitration cases, it's opening new grounds, okay? And I don't think that is that's contradictory. So I've not seen, for the cases that I've read, I've not seen contradictory judgments. The only thing I'm saying, courts are also manned by human beings. There are areas which maybe they could have skipped, like what I said on the Murwatetu. That could be human, okay? Maybe if I was there, I could have advised the court, can you look at this issue, how do we deal with it, okay? Thank you, my lady.
Okay. Are you okay? Thank you. Thank you very much, Counsel. I'll now ask Honorable Judge Wasame to ask his question.
Thank you, Chair. Daktari, when did you discover this road, this grand road?
The road?
Yes.
When I was doing my research around 2017.
2017?
Yes.
Okay. Did this road pass through the LSK, which is a great stakeholder of the justice sector? Did you sell the idea of the road?
No. What I did, what I've done, I wanted to write a paper on it and publish it. As scholars, what you do usually is you write a paper, and so I was trying to. I've already got that data. After finishing my PhD in 2019, I say now those are the things which I would have liked to do and publish.
Okay, as a scholar.
And when I saw this opportunity, I said, let me come for it and inform the relevant authorities.
As a scholar, do you look at Raila 2017?
Raila 2017, yes. Yes.
What was the majority decision about? And what was the dissent about?
The decision
in terms of the qualitative and quantitative principles in election petitions.
Now, I want to say for election petitions.
I'm just talking about Raila 1 2017.
Yes. I want to say that, then I pin it to the.
Yes.
Yes. For election petitions, the basis for which Raila 2017 was not allowed was the fact that the irregularities did not affect the result of the elections. That was the basis.
2017 Raila was allowed?
No.
I'm talking about 2017.
Oh, 2017, that was 2013. 2017, the basis of that case was that the IBC had failed to open up and give information about specific forms which could lead to the accounting of the elections, leading to that provision in the Constitution that the elections could not be verified.
So what was the decision, the majority decisions based on? And what was the dissent based on?
The decision, the majority decision was based on, due to lack of evidence, okay, to the effect that the elections could not be verified, could not be, it could not be verified through those returns, then there was no elections.
What was the dissent about? What was the dissent about?
The dissent was that those documents were not could not affect the results of the elections.
Okay.
Yes.
There was a lot of criticism around the judgment.
Yes.
That the majority judgment did not look at the quantitative aspect of the election. And the court heavily relied on qualitative. What is your view?
In that judgment, I don't want to castigate the court, because when you come to court, you need...
Listen to my question.
Yes.
I said there was a lot of criticism on the majority decision, that they gave a lot of premium on the qualitative test without analyzing the quantitative test. What is your view?
I think that criticism is wrong. That's my view.
Why?
For the simple reason, for this short time, the court wanted verifiable evidence. That verifiable evidence, the quantitative evidence, was not there. And since it was not there, the court could not be able to make a decision on the quality of the elections.
Okay. To simplify it for you,
Yes.
the court looked at the qualitative test.
Yes.
It did not look at the numbers obtained by the winner. That was the criticism.
Yes.
So what is your view now that I have simplified the matter for you?
Now,
And that's my last question. I wish you well.
I still say the criticism was wrong, and I tend to agree with what the court, the decision of the court.
Okay, counsel. Although I think the judge was asking for looking for the reasons for that, but it's okay, we can move on. Honorable Judge Majaja, you can go ahead.
Yeah, thank you, Chair. I have a few questions. First of all, I've looked at your books. You are a prolific writer.
Thank you very much.
We thank you for that. Very few people write law books. So I think I do not have any particular questions about your technical writings. You have also provided for us published articles. But just a few issues, following up from some of the issues. One of the main areas my colleagues have followed on is the issue of jurisdiction
Yes.
of the Supreme Court. One of the decisions, whether rightly criticized or not, is one decision that talked about appeals from election petitions, that created this concept or doctrine of normative derivative. Have you heard of that? That the Elections Act is a normative derivative of the Constitution, and therefore appeals from election petitions are properly within the jurisdiction of the Supreme Court.
Yes, I've heard of that. Yes.
So what is the normative derivative? What is that doctrine? What does it mean?
That simply means that the rules and the regulations which govern elections emanate from the Constitution.
Mm-hmm.
Okay? And since those rules emanate from the Constitution therefore gives a format on how disputes should be resolved.
Mm-hmm. How is that connected to the right of appeal to the Supreme Court for election petitions?
Now, the argument is, because of that normative kind of argument, that cases which are heard in the lower courts should have their way to the Supreme Court.
In election petitions.
In election petitions.
Because of that doctrine, of
yes.
that principle.
Yes.
Now,